Good afternoon, and welcome to TCLE's program, Hot Topics and Welfare Benefits. My name is Linda Hoseman, and I will be presenting today along with my colleague, Trish Winchell. And now I want to get to the topics for today. On this slide, we have the topics that we hope to address today, and as you can see, there's a lot to cover, and you're going to learn about what various government agencies have been busy with this summer. There's a lot for you to consider as you move forward with your plans. And on that note, I'm going to turn things over to Trish to start with one of our hottest topics of the summer, ACA reporting.
Okay. I'm going to start with some lessons learned on ACA reporting from the reporting that was done for 2015. And I think the top lesson learned is that ACA reporting really was as complicated and as time-consuming as everyone thought it would be. There were not any real turnkey solutions. In most cases, it was not possible just to turn reporting over to a vendor, send a few feeds, and avoid devoting substantial time and resources to it. Some of this was because it was the first time through, obviously, but some of it is simply that this is not a W-2, not possibly as easily automated, a little more complicated, and with more one-off decisions. So the biggest takeaway is that companies need to be sure that they have the resources in place for 2016 that are necessary to comply with the ACA reporting requirements, especially given that the deadlines are being tightened in 2016. One of the particular problems the companies faced was the coding in lines 14 and 16 of the 1095-C. Line 14 are the codes where employers describe the offers of coverage that they've made. Line 16 is the code for employer relief or safe harbors for not making offers of coverage. There has been some additional guidance to help us in reporting for 2016, COBRA reporting, reporting on former employees, and multi-employer plan reporting issues have been dealt with. Mostly it will be a matter of becoming more familiar with the coding and what's expected and the appropriate codes to use. A final takeaway for companies that are engaged in M&A activity is that ACA reporting really needs to be a diligence item. In addition to talking about ACA compliance strategies in a transaction, buyers really need to be looking at how the ACA reporting was handled. In some cases, at least sample reports ought to be reviewed. And reporting for the year of a transaction should particularly be discussed. Especially in settings where transferring employees may stay on the health plan of the seller for a time, reporting really needs to be accurate and consistent between the buyer and the seller, particularly as to which entity is actually offering coverage. So there have been a few changes in the reporting from 2015 to 2016. First and foremost, the deadlines are earlier this year. The Form 1095s are due to employees January 31st, 2017, and the IRS filing deadline is March 31st for electronic or February 28th for paper. There has been no indication so far that there will be any extensions like we saw in 2016. So again, employers need to have their resources in place. And second, there's some transition relief ending. In 2015, employers with 100 or more full-time equivalents were required to offer coverage to 70% of their employees in order to avoid the big sledgehammer ACA penalty. In 2016, that's employers with 50 or more FTEs offering coverage to 95% of their employees, full-time employees, are able to avoid the penalty. This is really not a change in reporting because the employers with 50 or more employees were required to report last year. It is just a change perhaps in the consequences for reporting. This summer, the IRS issued draft 2016 forms and instructions, and there were a few minor changes. One is there is an additional code, or two additional codes for line 14 on the 1095-C so that conditional offers of coverage to a spouse can be reflected. And a conditional offer is an offer of coverage that's subject to one or more objective conditions. So if a spouse, for example, is offered coverage only if that spouse is not eligible for another employer's group health plan, that's a conditional offer and it's going to have to be reported as such. That information is needed because it may affect the spouse's eligibility for a premium credit for exchange coverage. There is now a reference on the form, on the portion of the form where we have to disclose the dependents who are covered under an employer plan. There's a reference to the Social Security number or other TIN. The other TIN reference has been added so that it's clarified that in the absence of a Social Security number, another TIN could be used for a dependent. The instructions that were issued this summer indicate that the multi-employer plan relief that was granted in 2015 has been extended to 2016. And what that means is that employers who are participating in multi-employer plans are not going to need to obtain the eligibility and offer information from the multi-employer plans for 2016. The instructions expressly say that the approach may change for 2017, but for now, at least, those data collection issues for employers who participate in multi-employer plans have been avoided. The notice given to employees specifically says that filing with the IRS 1040 is not required. The employee does not need to attach the Form 1099 and file it with the employee's 1040, which just clarifies a lot of, there was a lot of confusion on that issue in 2015, and it's just a clarification. And finally, and maybe most importantly, is so far there is no indication that there's an extension of the good faith standard for reporters that applied in 2015. In 2015, an employer who timely filed and made a good faith effort to comply would not be penalized for mistakes in reporting. I think many employers would find it comforting to have that standard extended to 2016, but so far there has been no indication that we have seen that the government intends to do that. I'm going to turn it back to Linda.
All right. Another area of interest regarding reporting from this summer are errors that were reflected when people did their ACA reporting. And as Trish said, you know, if the 1094 and 1095 returns were not accurate or timely, an employer may be subject to penalties. For calendar year 2015, reported earlier this summer, that penalty relief Trish mentioned is available if an employer did not file or furnish accurate returns but was able to demonstrate that it made a good faith effort to comply. The IRS has been hosting seminars and has stated that correcting errors is part of making a good faith effort to file complete and accurate returns in order to qualify for that automatic relief. By the way, if you don't qualify for the automatic relief, you may still be able to qualify for making your filings if you're able to demonstrate a reasonable cause. Now, there are two main errors that were triggered during the time of filing. There was the full rejection error. That's the return was not accepted by the IRS. It was completely rejected and would need to be refiled. And then there were returns that were accepted with an error message. And the IRS has indicated that employers must correct either error by filing a full and complete return, not just fixing the error parts as soon as practical. Now, one of the most common errors that we're seeing is taxpayer identification or Social Security number errors. These are usually indicated on forms that were accepted by the IRS, but they were accepted with errors. And there could be a number of reasons that this error message can be triggered, including name changes, employer keying errors, or other possible mismatches. The error message doesn't indicate where you have family coverage, which member of the family number is causing the error or name. The IRS indicated that no employment action should be taken on the basis of getting one of these errors. In other words, you should not fire somebody because you got a notice that there was a mismatch. Rather, it appears that solicitations should be conducted to try to get the correct name and number match. And you want to be careful that you comply with all laws when doing that solicitation, such that you don't want to display somebody's Social Security number or do anything that when you're doing that solicitation. You really have to ask them to come forward with how they file their information. If a correction of an error is not provided to the IRS, then the IRS may try to assess a penalty against you. The defense to that penalty will be that you made a good faith effort through the solicitation process, so it's very important that you document what you do.
Okay, also this summer, in June, the first wave of marketplace notices were sent to employers by the federal exchanges. The notices, these are notices from the exchange that advise employers that an employee has received a subsidy for exchange coverage and that the employer may be assessed a penalty. The notices are sent if an employee enrolls in coverage, receives a subsidy, and provides an address for the employer. And these notices are being sent to whatever address the employee provided. So for employers with multiple locations, this can be a problem. Employers have to respond or may need to respond to these notices within a limited period of time, and they may need to be sure that notices sent to outlying locations get to HR or to whoever is tasked with handling them promptly. Employers have 90 days to respond if they want to appeal one of these notices, and the regulators have not shown sympathy for claims that the notice was sent to a small outpost somewhere where no one knew what to do with it. So what the notices advise employers that they can appeal the marketplace determination that the employee was entitled to a subsidy. Now, an employee is not entitled to a subsidy, obviously, if they have received an offer of affordable minimum value coverage from the employer or if the employee has enrolled in coverage. So if an employer can establish either one of those things, the employer should appeal the notice in a timely manner, appeal the determination in a timely manner, and should include substantiation of its appeal. So showing you would include perhaps enrollment materials that would establish that an offer that the employer made was affordable, or enrollment materials showing that an employee actually enrolled in coverage, and perhaps the summary of benefits showing enrollment in minimum or showing that the coverage offered was minimum value coverage. It's important to note that grounds that go only to whether an employer needs to pay a penalty as a result of a failure to offer coverage are really not subject to appeal at this stage of the process. So for example, we have had several clients notified that someone who never worked for them was a person who got a subsidy, or someone who did not work for them during the period in question perhaps was someone who got a subsidy. If an employer appeals and tries to establish that the employee who was the subject of the marketplace notice is not their employee, or perhaps was not a full-time employee, and that's the reason they weren't offered coverage, the employer will likely get a letter from the marketplace notifying the employer that their appeal has been rejected and advising that the marketplace doesn't have any authority to consider the grounds that they've set forth for the appeal. That doesn't mean, of course, that the employer is going to pay a penalty. It just means that that is an issue to be raised later in the process if the IRS should ultimately assess a penalty. And now I'm going to turn it back to Linda.
All right. One of the other areas of review and concern for 2016 and beyond is your contingent worker coverage under the ACA. As you're probably aware, because we've said this in many seminars, the ACA requires applicable large employers to offer health coverage that's affordable and meets minimum value to its full-time employees or pay a penalty. There are two types of penalties. One that's the smaller penalty, which is $3,240 divided by 12 for each full-time employee receiving a premium tax credit that month, up to a ceiling of the larger penalty amount. If an offer is made that's not the right type of coverage and a full-time employee goes and gets subsidized coverage on the exchange. The other penalty is triggered if the employer fails to offer minimum essential coverage to at least, as Trish mentioned, 95% of full-time employees for 2016 and beyond, and a full-time employee receives subsidized coverage on the exchange. This penalty is $2,160 divided by 12, and you're probably thinking, Linda, you said the other penalty was $3,240. How can you say it's larger? Because this one is multiplied by the number of full-time employees minus up to 30 if this penalty sticks in. So it's really important for 2016 and beyond that we identify who is a common law employee of an employer. Remember, for 2015, it was only 70%, but 95% is a high number. So the ACA defines employee using the IRS's common law employee standard. It's a fact-based inquiry, and the employer's use of a designation is not significant. It's not a significant fact. So if you call somebody, you know, a 1099 employee or an independent contractor, that's not going to be dispositive for the IRS. So you need to carefully look at your contingent worker population and make a determination as to whether the workers are in fact more likely to be employees. If you classify an individual as an independent contractor and therefore don't offer them coverage, and they factually should be considered an employee, they will count in your 5%. And if you exceed that 5% and somebody goes and gets subsidized coverage on the exchange, now you're in that big penalty that I warned you about. If you use a staffing agency to lease workers, you should be extra careful to set up the contract with that staffing agency to make sure that the offer of coverage by that agency will be considered an offer of coverage by your organization. So the IRS gave us, you know, they kind of realized that a lot of people had these leasing type situations, and they gave an out where there was a contract and where that leasing agency made an appropriate offer of coverage to the workers, and the workers take that coverage. The special contract language has to be in there, and the entity that is using the leased worker, so you as the employer, would need to pay an additional fee under the contract for those leased employees who actually elect the leasing agency coverage. So that has to be tracked. And remember, it has to be tracked on a month-by-month basis. You can't do an average, like we averaged covering 95%, because some months we covered 98% and some months we covered some number below 95%, because for those months you're below, the IRS would assess a penalty against you. Okay, now it's back to Trish.
Thanks, Linda. I want to talk for a minute about health plan opt-out payments. Some employers pay employees who decline health coverage or opt out of health coverage. And this can have ramifications for determining whether or not the coverage is actually affordable for purposes of the ACA, which of course is important because an offer of affordable minimum value coverage to a full-time employee will enable the employer to avoid the penalties that Linda was discussing. The IRS's position is clear that an unconditional opt-out payment has to be added to the employee contribution amount for purposes of determining whether the coverage offered is affordable for ACA purposes. And they have issued proposed regs that make that position clear. So, for example, the IRS's view is that if an employer offers health plan coverage and charges employees $100 per month, but the employer also offers $200 a month to employees who opt out of coverage, for the ACA affordability test, the cost of coverage is $300. The regs say that they're anticipated to be, or final regs are anticipated to be effective January 1st, 2017, but the Internal Revenue Service has said that until at least 1/1/2017, or until the regs are effective, they've given some relief from their position for employers who have designed their coverage and were unaware of the position. So employers are not required to treat opt-out payments as employee contributions as long as the opt-out was adopted before December 16th, 2015. Now, employees can regard an opt-out payment as additional contribution. So if the opt-out payment makes coverage unaffordable for ACA purposes, the employee may be eligible for a subsidy, even though the employer can claim that the employer made an offer of affordable minimum value coverage. So at least until plan years for 2017, we kind of have the best of both worlds in that situation. But employers who have opt-out programs are going to want to examine them carefully to see if changes are warranted for the 2017 plan year. I would note that the IRS position does not apply to what they call conditional opt-outs. And so if a payment is made, for example, only if an employee can show that he or she has coverage somewhere else or with another employer, that opt-out payment is not going to be considered part of the employee's cost for purposes of the affordability test. So employers will want to take that into account in the event they are re-examining their plan design.
Okay. With the tremendous amount of focus on healthcare reform, we wanted to take the next few slides and let you know that it's still important to remember that there are other health plan compliance matters that you need to make sure you're complying with. In particular, privacy and security of health data under HIPAA is also a hot topic both with government regulators and participants. On July 11th, 2016, the Office for Civil Rights of Health and Human Services rolled out its latest wave of audits of covered entities and business associates. The first set of emails were sent to, according to them, 167 covered entities, but it is expected that this whole process, there'll be at least 200 to 250 entities that are affected or sort of touched during this audit process. The initial audits are designed to focus on policies and procedures, and there is both a desk audit piece and an on-site audit piece. So by desk audit, I mean that you send information into the agency that they've requested, and by an on-site audit, well, that's the one you don't like. That means the agency comes to your neighborhood. The first group of the 167 entities was a desk audit. It was for covered entities. OCR has indicated that desk audits of business associates is actually expected to begin late this month, and then on-site audits are expected to begin in early 2017. And they are anticipating that an on-site audit will be very comprehensive and last 3 to 5 days. So that's 3 to 5 days that you have somebody from OCR on site. The audit process commences with an email to verify contact and other information of the target entity. And there's also a pre-audit questionnaire. One interesting point to note is that OCR indicates that it is an entity's responsibility to check its spam filter for the initiating email, because they're doing these as blast emails. So sometimes if you have a good spam filter, that email will get picked up as not something that should go through, and OCR considers you responsible for that anyway. So you need to check your spam. At this point, the 167 entities hopefully check their spam, but if you're a business associate, you should be checking your spam now because your blast of emails may be on the way. The audits themselves really focus on privacy notice practices and provision of privacy notices, an individual's right to access their protected health information, breach notification compliance, and security risk analysis and management. So the takeaway here is even if you're busy with the ACA and your reporting and disclosure and all that new stuff, it's important to keep up with your HIPAA policies and procedures. It would not look good if you get an on-site audit and there's an inch of dust on your policies and procedures notebook. You should perform your security checks, and you should continue to do HIPAA training of new hires and individuals to make sure that you stay in compliance. Now, in addition to audits, Health and Human Services also recently put out guidance, special guidance on ransomware infections of health information that they say have become pretty widespread. And I actually read something, I think from Anonymous, where he was talking about, yesterday, he was talking about why he had done some ransomware to a New York hospital because they had a practice that he didn't agree with. The guidance strongly suggests that attacks likely constitute reportable breaches of PHI, but it does say that it's ultimately that fact-based inquiry, and the entity can do the risk analysis to determine if there's a low probability that protected health information has been compromised. As a reminder, because we like to remind you of all these things you need to do, the four-factor risk analysis you should do looks at the nature and extent of the protected health information that's involved, the unauthorized person who used the PHI or to whom the disclosure was made, whether PHI was actually acquired or viewed, and the extent to which any risk was mitigated. So you may think, well, ransomware, how do, if they're just sort of holding it, this is one of those things where they sometimes take a hold of your computer and they hold it hostage and say, you need to, pay me money so we'll give you back your files. And that's looked at if it's unencrypted information that somebody else has control of that information, and so likely you're going to have some sort of notice requirements. The guidance itself is actually very well written. It's question and answers, and it does, help you in other areas to make sure you're in compliance with HIPAA. So I recommend reading it. Finally, please note that in addition to random audits and publishing guidance, Health and Human Services continues to settle multiple HIPAA breach matters. As of July 31st, Health and Human Services indicates that it has settled cases resulting in almost $40 million. I feel like I should put my pinky up to my lip when I say that. $40 million in fees. And the most recent settlements seem to focus on business associate failure, so you should make sure you have your business associate agreements with people. That the health plan has them with people they share protected health information with. Other key areas are demonstrating that security, compliance, risk analysis is being done. It's not just enough to say you have, security. You have to be analyzing it and looking at it. One of the things that Anonymous said in that article was that the hospital was lazy with respect to mitigating against risk, and that's why he was able to get in and, hold the information hostage. You should be conducting your training and reviewing and following your HIPAA policies and procedures. So remember, make sure you have robust HIPAA compliance and check your spam. Another non-ACA topic resulting in increased enforcement and additional guidance this summer is under Mental Health Parity and Addiction Equity Act of 2008. This act generally requires health plans to make sure that the financial requirements and treatment limitations applicable to mental health or substance use disorders are no more restrictive than the predominant requirements or limitations applied to substantially all medical or surgical benefits. While this may sound simple, it's really not that easy, and the DOL has indicated that enforcement is ongoing. The DOL has even found it necessary to provide some additional guidance related to mental health parity. So in April of this year, the IRS, HHS, and DOL issued Part 31 of the Q&As for ACA implementation. that also had mental health parity guidance in them. Question and answer 8 addressed the quote, substantially all, quote, and predominant tests for financial requirements and quantitative treatment limitations, clarifying that any such requirements or limitations need to be based on plan-specific data, and to the extent that that's available, as opposed to, for example, if you had an insurer, they can't look to their whole population of covered plans to determine what the substantially all and predominant tests, they should look at the plan specifically in question. In addition, that same Q&A, and actually more importantly for most employers, addressed disclosure obligations under the mental health parity rules. The Q&A reiterated that a plan has to disclose the criteria for medically necessary determinations upon request and cite the reason for any denial of benefits with respect to mental health or substance use disorders on a timely basis or be liable for penalties under ERISA. So what does that mean? This is if somebody requests the information about why you had a medically necessary determination, you have 30 days from the request to provide them with the information, or you may be subject to the up to $110 a day penalty under ERISA. The Q&A clarified that instruments under which a plan is established include documents with comparative information on medically necessary criteria for both medical, surgical, and mental health substance use disorder benefits. So you need to not only just pay lip service in your plan that your medical, surgical, and mental health substance use benefits are on par, but you need to do comparative information to be able to demonstrate it. As well, you have to show the processes, strategies, evidentiary standards, and other factors used to apply a non-quantitative treatment limitation with respect to medical, surgical benefits and mental health substance use disorder benefits. In other words, a plan must be able to demonstrate that it's analyzed and compared limitations between mental health, substance use disorder, and medical surgical benefits, and they have to provide this information if there's a claim and appeal process where somebody is appealing a mental health benefit limitation. Question and answer 9 in this guidance provided further information on whether a plan should be able to provide so it can be determined that a non-quantitative limit does not operate in a manner more stringently to mental health than to medical surgical. Meanwhile, in June, the Department of Labor issued a document called Warning Signs, Guidance for Health Plans that may indicate noncompliance with mental health parity. And this is really important for those of you who didn't understand what I meant by non-quantitative limitations, because this describes it quite well and is worth a read. So Mental Health Parity and Addiction Equity Act looks at both quantitative treatment limits and non-quantitative treatment limits beyond just the plan terms. Quantitative treatment limits, as you might imagine, are numerical limits on treatment, such as, visit limits. Those are pretty easy to spot. Non-quantitative treatment limits are non-numerical limits on the scope or the duration of benefits, such as a pre-treatment authorization. The DOL indicated that such non-quantitative limits are not banned. They're just something you have to look at further. And the purpose of the warning signs is to help plans identify these provisions that will require the further inquiry to determine compliance. So the guidance focuses on a number of things, and I just want to run through a couple of notice. If you have a blanket pre-authorization requirement for all mental health and substance use disorders, and you don't have a blanket pre-authorization requirement for medical surgical benefits, that seems pretty obvious that you might have a problem. But what if your plan contains that for both sides, medical, mental health, but you're only enforcing it for one side? Those are the things that are going to be looked at by the Department of Labor if there's an audit. Other things that you need to look at are medical necessity review, prescription drug pre-authorizations, some fail first protocols. If you have a probability of improvement, for example, that you'll only allow inpatient treatment for mental health if it seems like that it will result in improvement, and you don't have the same limit on medical surgical, it can be an issue if you require a written treatment plan for mental health benefits and you don't have a written treatment plan for medical surgical. That also can be an indication. So again, I suggest that you go through and make sure that your plan document provides parity, but also that operationally you're checking to make sure that there is parity between mental health and the mental health side and the medical side. I actually have a client who was trying to do something for a benefit that you don't have to cover. I don't want to go into that benefit, but it had a substantial mental health component to it in addition to a surgical side, and they were going to try to limit that coverage to in-network only. And while they didn't have to cover the benefit, there was a definite risk that if they had covered the benefit but said it was limited to in-network only, that they would have run afoul of this law. So it's something you need to think about as you go forward.
Moving on to a new topic, we have seen a number of issues arising with respect to former employees who are on COBRA who want to move to marketplace coverage. And there are some pitfalls to be aware of in connection with offering with COBRA offers and a desire to switch later to marketplace coverage. A COBRA participant, a person who's participating as a COBRA participant can elect marketplace coverage during an open enrollment period. So this November, when the open enrollment period for the marketplace starts, someone who is on COBRA can elect marketplace coverage and can drop COBRA once that marketplace coverage becomes effective. A COBRA participant is also able to elect marketplace coverage when they are when COBRA coverage ceases to be available. So if someone's employment has terminated, they have been on COBRA for 18 months and the 18-month period is run and coverage is no longer available, at that point there is a right to elect marketplace coverage. But an employee who drops COBRA voluntarily does not have a special enrollment period during which they can enroll in the marketplace. And as a result of this, employers who want to temporarily subsidize COBRA coverage find sometimes that no good deed goes unpunished. Sometimes an employer may agree either in a severance agreement or as part of a general reduction in force arrangement to pay the cost of coverage for employees who let COBRA for, say, for a 3-month period, for example. At the end of that 3-month period, the cost goes up to the permissive 102% of the full cost of coverage. And at that point, the marketplace coverage may become more attractive to the employee. But the employee cannot drop COBRA coverage at that point and enroll in the marketplace because there would be a gap in coverage. There's no right to enroll on the voluntary dropping of coverage. If this is a problem, if employers want to address this issue, some employers have considered simply making a cash payment to employees who are eligible for COBRA coverage for what would otherwise be the cost of coverage for some period. It would be an unrestricted cash payment. So in some cases, employers don't find that as desirable. Another option is to offer alternative coverage for a certain period, fully subsidized alternative coverage in exchange for a COBRA waiver, because once alternative coverage expires, the employee is eligible to go onto the marketplace if the marketplace provides a better deal. So just things to keep in mind in designing a severance agreement or a reduction in force arrangement. Now, COBRA can be an effective tool for filling a gap between the loss of employer coverage on termination of employment and the ability to obtain marketplace coverage, but it does take some planning. For example, if Joe terminates employment today, September 20th, and loses his employer coverage at the end of the month, he can elect exchange coverage on September 20th, but it won't take effect until November 1st, which is the first day of the second month after he enrolls. So he has a gap in coverage. He has a gap in coverage for the month of October. One way to deal with that is to enroll in coverage on the enroll in exchange coverage on September 20th, and then later elect COBRA to cover the October gap and drop it once the exchange coverage begins. That's permissible, and the employee can even wait to see if he needs coverage in October, and because of the 60-day window in which COBRA coverage can be elected, could elect the coverage retroactively. But it does take some planning, and I think the lesson from some of the situations we've seen with COBRA is that it is important for employers to communicate clearly to employees the interplay between COBRA coverage and eligibility for the exchange. One other issue we've seen, and this is not really a new issue or a new rule, but for some reason we've seen it several times recently, where employees on COBRA have delayed signing up for Medicare. And the end of COBRA coverage is not a Medicare special enrollment event. So unfortunately, employees who delay while they are on COBRA can face a gap in coverage between the time they are eligible for Medicare coverage during an open enrollment period and the time they lose their COBRA coverage. And they can also incur the late enrollment fee for Medicare because they have not signed up for coverage when they were first eligible, which is upon the termination of their employment and the end of their active coverage. And again, employers just may want to consider their communications with employees who are terminating who may be eligible for Medicare and consider clearly communicating the relationship between the two events. Back to Linda for a wellness plan update.
This has been a hot topic for a while, and there's been a lot that's gone on here. But on May 16th of this year, the Equal Employment Opportunity Commission, the EEOC, issued final regulations governing wellness programs under the Americans with Disabilities Act and the Genetic Information Non-Discrimination Act. These final rules are intended to help employers design wellness programs and the incentives thereunder to comply with the ADA and GINA. One key point to note is that there is not full alignment between the EEOC rules that we're discussing today and the HIPAA wellness rules that came from the other three entities that I keep talking about, you know, the IRS, the DOL, and HHS. These EEOC final rules apply to wellness programs that are subject to this beginning on or after January 1st, 2017. And, you know, by way of background, the IRS, DOL, and HHS got wellness rules out relatively quickly, and there's been a lot of confusion as to how the ADA and GINA applied when there was a wellness plan. And employers who seemed to do everything they could to comply with the HIPAA wellness requirements from IRS, DOL, and HHS were actually being sued by the EEOC for perceived ADA violations. And the EEOC was a little bit late to the dance on this one, and they tried to backdoor compliance with these lawsuits, and then Congress stepped in, and there were some acts passed, and on until we finally got these rules. These are the relevant final rules that you need to comply with if you want to be sure that you are compliant with the ADA. So let's get into the rules a little bit. The ADA final rule describes how an employer may use an incentive to encourage an employee to participate in the wellness program that makes a disability-related inquiry or requires a medical exam. So this includes both HRAs, which tend to have disability-related inquiries, and medical exams would be like a biometric screening underneath a wellness program. If there is not a disability-related inquiry or medical exam, then the ADA doesn't apply and you don't have to worry about these EEOC rules. However, if the EEOC rules apply, then it doesn't matter if the wellness program is offered inside or outside of a group health plan. These rules will apply. And the ADA requires the plan to be voluntary. So in other words, you can't have a denial of coverage for not participating in the plan. You can't take adverse employment action, fire somebody for not participating in the wellness program. Confidentiality must be protected, and notice must be provided, and I'm going to get a little bit more into notice on the next slide. Not yet. Finally, under these rules, the maximum share of the incentive that's allowed for complying with the program is 30% of the lowest cost for self-only coverage of the employer, or if there's no employer plan, it's 30% of the cost that a 40-year-old non-smoker would pay for self-only coverage under the second lowest cost silver plan on a healthcare exchange. Similar rules actually apply with respect to spouses under GINA. Again, GINA applies to all employer-sponsored wellness programs that request genetic information, whether or not they are part of an employer health plan. And the EEOC provides that GINA does not prohibit a spouse from providing information on his or her current or past health status, but the spouse must provide prior knowing and voluntary authorization when providing the genetic information. Again, the program must be reasonably designed to promote health or prevent disease, and that's a similar requirement that the ADA has. You can't just sort of give an incentive with no sort of tying it into promoting health or preventing disease. And programs that only consist of the test, screening, or collection of health-related information without any follow-up are not considered reasonably designed to promote health or prevent disease unless the information is used ultimately to design a program that may address something that comes up in your population that's found doing these tests. So the GINA rules allow an additional 30% of the total cost of self-only coverage for the spouse's information. And the GINA rules confirm that there can be no incentive provided to receive a child's genetic health information. So you can't incent somebody to provide information about their kids. There is a special rule for tobacco matters. If the program simply asks the question but does not perform any kind of test regarding tobacco usage, the 30% limit can be increased to 50%. That's the incentive limit. However, if you do a test for nicotine or tobacco's presence, now you've got a medical test, you're back to the 30% limit, of the lowest program, self-only, all the stuff that was described. So it's really, if you're going to have one of these programs, these are rules you should start to comply with because it goes into effect starting next year. And I think most of you are probably designing your programs, even as we speak, or may have already designed them. Now, one other point to note about this wellness plan is, again, I mentioned there was a notice, and on June 16th, so about a month after the rules came out, the EEOC issued a model notice along with some Q&As related to the model notice in wellness And it covers the information that needs to be in the notice that's indicated on this slide, so you can read that and know what you should put in your notice. But I would also take a look at the EEOC's model notice. And now, some of the best information Trish is going to give you regarding welfare plan, SPDs, and best practices.
It's really a welfare plan document and SPDs best practices, and specifically I want to talk about forum selection clauses and limitations periods. If you are considering any plan, as you're considering any plan amendments for 2017, we would urge you to consider the addition of a forum selection clause and a limitations period to any welfare plans that don't already have one. And for that matter, your retirement plans should contain these clauses as well. A forum selection clause just ensures that all plan litigation, or requires all plan litigation to be brought in one forum, for example, in the Federal District Court in the Eastern District of Missouri or in the Northern District of Illinois. This is not just for the plan's convenience. It can be critical to ensuring that the plan's interpreted consistently for all participants. Just real quickly, for an example, we recently defended a pension plan without a forum selection clause in 2 lawsuits, one in the Southern District of Illinois and one in the Eastern District of Missouri. The dispute was how to interpret a plan provision that dealt with the calculation of the pension benefit. The court in the Eastern District of Missouri said the plan administrator's interpretation was correct and that he had calculated the benefit correctly, and that decision was upheld by the 8th Circuit. The court in the Southern District of Illinois saw it differently and told the plan administrator he had to calculate the benefit differently than he had been. So the administrator was faced with conflicting orders and possibly having to calculate the benefit differently depending on whether a plaintiff lived in Missouri or Illinois. Fortunately, the 7th Circuit overruled the Southern District of Illinois and the conflict was avoided. But forum selection clauses are helpful should your plans unfortunately be subject to litigation. Forum selection clauses have been litigated themselves. The enforceability has pretty much been upheld across the board. There are 4 district courts that have held those clauses to be unenforceable, and 2 of them in 2016, so it's unclear whether the tide is turning on that. But the one appellate court that has decided on the enforceability of these clauses is the 6th Circuit, and it upheld the enforceability. And the Supreme Court has denied cert because there's no split in the circuit. So until there is a definitive ruling to the contrary, we would recommend adding that clause as well as a limitations period in your plan. So for example, just any litigation has to be brought within 1 year of the date of the final administrative decision. And I will move on and give it to Linda to close things out.
We've got a couple other things, and we don't have a whole lot of time, so I just want to make you aware of what else is out there. Health and Human Services has put to use new rules under Section 1557 of healthcare reform, which prohibit discrimination on the basis of race, color, national origin, sex, age, or disability in certain health programs or activities. So it used to be under ERISA, in the IRS code, we used to say non-discrimination in plans really was about high pays versus low pays. There wasn't this articulated non-discrimination that you had in other employment laws, and HHS has now put that in under 1557. It's only for insurers and entities that receive federal financial assistance, so it may not apply directly to a self-funded plan. In our practice, where we see it is if you have a retiree medical plan that receives drug subsidies or is an employer group waiver or EGWIP plan, then you receive these federal funds and are covered. And most of the time your prescription drug provider is helping you comply, although there's a couple things you need to do. If you haven't heard from your prescription drug provider and you have a retiree medical drug program, you need to reach out. You have new Form 5500s coming, and if you were a small employer and you used to rely on that exemption for filing. That is now gone. We will have new SBC templates that, if you're a calendar year plan, will apply to you, basically for the 2018 plan year, so open enrollment before that in 2017. And you just can go look at the template and use it. It's a little bit more user-friendly than in the past. You can actually refer to SPDs and things like that. And then there's some really great guidance if you have expats, and expats, true expats or inpats, as defined. You need to make sure that your plan complies as an accepted benefit under ACA in order to take advantage of requirements. And I realize now we are actually out of time. Our contact information is contained in these slides here, so if you want to reach out because we didn't get to your question, please let us know. Again, thank you very much for your time today, and please don't hesitate to follow up with us.